Wait. C'est parti.
Okay. Hello and welcome to our webcast for October 4, 2019. My name is Christian Aubry and this is Amy Asbrook, the director of Toujours Vivant, Not Dead Yet.
Hi.
Toujours Vivant, Not Dead Yet is a non-religious organization by and for people with disabilities and our allies. We believe that the choice to die is not free if old, ill, and disabled people don't have a free choice in where and how they live, and that must change.
Okay.
Today's topics: disability rights activist call for appeal of Truchon decision. Second one, Dutch prosecutor brings consent question to Supreme Court. And the last one, Italy's Constitutional Court rules assisting suicide is not always a crime. So Amy will help us through those subjects. And the first one is very, 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 very important.
Yes. Okay. Oh my goodness. I somehow got something screwed up here. Anyway, what's that? Make it go away. Okay. The Council of Canadians with Disabilities, CCD, and the Canadian Association of Community Living have issued an open letter to Attorney General David Lametti asking him to appeal the Truchon decision. The letter comes 2 days after Prime Minister Trudeau said in a French language debate that he would not appeal the Truchon decision if he were reelected. Also, the Quebec's Attorney General has said that they won't appeal the decision.
From news of this morning, we know that.
Yeah, okay. Stupid thing in my face. It won't go away. Go away.
No, it's not you. You should not go.
Sorry. Okay. However, since the appeal deadline falls before the federal election, the Attorney General will have to request an extension, file an appeal, or lose the opportunity to appeal the case if action isn't taken. So we need the AG to take action now.
Yes, and if they don't do appeal, you will see what happens.
Right, it would be bad, very bad.
Yeah.
As of October 4th, 65 disability organizations and allies have signed on to the open letter, which is being released today. The text of the letter reads as follows. Regarding advocates' call for disability rights-based appeal of the Quebec Superior Court's decision in Truchon and Gladue. We, the undersigned members and supporters of the Canadian disability community, are deeply troubled by the Quebec Superior Court's decision of Truchon contre Procureur Général du Canada.
Against, sorry.
Yeah. Right, did I?
It's you who's supposed to be English.
Yeah.
Not mine, not me.
No, sorry. It's actually in French.
Oh, yeah.
Because the decision is in French.
Because it's in Quebec.
So it's
Truchon
contre Procureur Général du Canada.
You don't translate that part. Okay,
right.
Great.
As you are aware, the decision has struck down the reasonably foreseeable natural death criterion of Canada's medical assistance in dying legislation. As Attorney General of Canada, we urge you to file an appeal of the decision immediately. We find this decision to be concerning for the following 3 reasons. Number 1, it failed Parliament to balance the interests of individuals, interests of society, effectively limiting Parliament's capacity to pursue social targets as well as substantive equality and inclusion. Justice Christina Baudouin arrives at the conclusion that the end-of-life criterion violates Section 7 and Section 15 of the Charter by rejecting a key objective of Parliament, erasing any need for a Section 1 analysis of the reasonable limits. Parliament outlined the following societal objective in the preamble to the legislation. And this is one of the objectives that we talked about last week that Canada had in creating the law. One was to prevent suicides, and the other is it is important to affirm the inherent and equal value of every person's life and to avoid encouraging negative perceptions of the quality of life of persons who are elderly, ill, or disabled. And if you recall, I said last week that basically the judge said that that was too broad and couldn't count as a legislative goal. In fully rejecting this objective, the court has limited the authority of Parliament to govern toward an inclusive and equitable Canada. This is a dangerous precedent.
Yeah. So if a court rules Canada, you don't need a government.
Right.
You just have to resign and let be ruled by judges.
Right. Parliament intentionally included the end-of-life criterion in the legislation as a way of achieving the above objective and also of preventing suicides. Is it reasonable for Parliament to limit the individual interests of Monsieur Truchon and Madame Gladu, being autonomy, in order to promote the interests of society, equality, and inclusion? That's a question mark. And again, the autonomy interests we question because people don't have access to community living. Without an appeal, we may never know. The Supreme Court must weigh in on this flawed analysis. Point 2. The decision will entrench stereotypes and exacerbate stigma for Canadians with disabilities, contributing to the adversity and oppression experienced by this vulnerable group. Without the equalizing effects of the end-of-life criterion, which guarantee that the common thread between all persons who access the assisted death in Canada is that they are all dying persons. All dying. Persons with disabilities will be able to gain access ultimately because they have a disability. A worse stereotype couldn't be institutionalized by law, that disability-related suffering, largely caused by a lack of support and inequality, justifies the termination of a person's life.
Yeah, that's clear for us.
Right, and that is, something we don't want to have. We don't want that written into law. And the point being that the idea that somebody's at the end of life or that their death is reasonably foreseeable applies to anybody, regardless of whether they have a disability or not. That wasn't what the judge said, but that's why we think the ruling needs to be appealed, because we think the judge is wrong.
Yeah, the judge is wrong comment on dit ça en anglais? En droit, en fait, en droit.
In law, in fact.
In law and in fact, yeah.
Right. Yeah.
And it's the reasonable cause to appeal something.
Yeah. Okay. I finally got that stupid thing to go away. Canada must avoid sending a message that having a disability is a fate worse than death. Canadians with disabilities are already bombarded daily with reminders that they are not welcome and undervalued. We must not compound this harm by entrenching in law the message that others who share their conditions will receive our full support if they choose to die prematurely. This message fits too neatly into the stereotype of a life featuring disability, bad life, full of only of suffering and pity, which is the way she talked in her decision. She
Yeah.
used lots of language, and I
And
pointed some of that out.
It's
last week.
basically false. Most of people who are living, even with disability, like their life.
Right, and they'd like it a hell of a lot better if they could get access to community-based services.
Oh, yeah.
Such a narrative already exists. Canada must appeal the decision to prevent additional stereotyping and stigma and to substantively protect the Section 15 Charter rights of persons with disabilities.
The same section that the judge said the fact that life is have to be in the hand for permitting the assisted aid in medical aided dying. This is the one that we said we should protect.
Okay, the third point. Without the end-of-life criterion in place, Canada's medical assistance in dying legislation will further violate Article 10 of the United Nations Convention on the Rights of Persons with Disabilities.
And Canada is a signing of
Yes.
this thing.
Yes. Article 10 of the CRPD reads as follows. States parties reaffirm that every human being has the inherent right to life and shall take all necessary measures to ensure its effective enjoyment by persons with disabilities on an equal basis with others. So that doesn't mean sticking people in nursing homes if they need assistance. That means enabling them to stay in their own homes. But of course, that's not what's happening. By offering medical assistance in dying to people with disabilities on the basis of disability, Canada would be further violating international law. If every Canadian who suffers cannot access a medically assisted death, and yet a Canadian who suffers and has a degenerative disability can access it, it is precisely their disability status that sets them apart. And that is not permissible.
Not at all.
No, it's not. Oh, right. Canada is already not taking necessary measures to ensure effective enjoyment of life by people with disabilities on an equal basis with others. This is a case after case of Canadians whose medical and support needs are not being met, causing them to consider, if not seek out, death. And there's in the letter that we sent out to the mailing list, there are several links to articles that talk about people who've made such requests. Canada's medical assistance in dying regime already concerns the UN Special Rapporteur on the Rights of Persons with Disabilities, Catalina Devandas Aguiar, who shared at the conclusion of her study visit in Canada that she is extremely concerned about the implementation of the legislation on medical assistance in dying from a disability perspective. And this is before the end-of-life criterion was struck down.
Before.
Right, exactly.
So just imagine what it is after.
Right. Yeah, it's bad news.
Yep.
Minister Lametti, as Attorney General, we urge you to appeal this decision up through the Supreme Court. Not to do so, we believe, would be a failure on the part of the government to defend persons with disabilities from significant and tangible harm. After extensive consultation by parliamentary committees and public debate, your government crafted this legislation intentionally and purposefully. We trust that as Attorney General, you will take the steps needed for its vigorous defense. Canadian human rights are at stake. And the 65 signatories, we're not going to read them all, but they're the Council of Canadians with Disabilities, Canadian Association for Community Living, People First of Canada.
Yeah, small organization.
Yeah.
Canada.
Canadian Disability Studies Association, Disabled Women's Network of Canada,
Ontario something.
Citizens with Disabilities Ontario.
Yeah.
Toujours Vivant, Not Dead Yet.
Yeah.
Euthanasia Prevention Coalition. A few, groups. Vivre dans la dignité, Living with Dignity, and the Physicians Alliance Against Euthanasia, I think, is also there somewhere. There are a lot of, there are 65, in fact,
Yes.
groups. So.
And one thing that I don't understand, where are the group who are against suicide?
Yeah, that's a big problem. Right. Okay, your part. The Attorney General can be reached by email at webadmin@justice.gc.ca or by phone at 613-957-4222. I'm not going to tell you what to do or say. I'm just telling you how to contact the Attorney General. That's up to you. Okay, our next topic. Dutch prosecutors bring consent questions to Supreme Court. Prosecutors in The Hague are seeking clarification of legal questions surrounding the dismissal of charges against a nursing home doctor who euthanized a 74-year-old woman with dementia based on an advance directive, despite indications that she wasn't ready to die. Yeah, there were indications. We first reported this story in 2017, and in our text version, there's links. When the committee that reviews euthanasia in the Netherlands declared that putting a sedative in the woman's coffee and having her physically restrained during the injection nevertheless amounted to a good faith compliance with euthanasia safeguards. Yay!
Yeah, you just have to remember that Netherlands, Belgium, and Canada have almost the same law. And this is the same principle. Doctor at 100% covered and immunity. Like she said.
What I said.
Okay. And they just have to say, oh, I was thinking that was the patient was needed.
Right.
And they are automatically acquitted. Yeah. That's the law in all those three countries. Right. So whatever the doctor done or wish or whatever, you just have to say the court, I was thinking that it was.
That's what the person wanted. So.
Yeah. And that's it. He's like it.
Right. So prosecutors brought charges against the doctor last fall, and there's a link to the article that we did at that time, which were dismissed by a court in September. The request for clarification is not an appeal. The doctor is not at risk for punishment.
Not at all.
The prosecutor's petition to the Supreme Court is only a request for guidance on what to do when an incapable person gives mixed signals about their wishes.
Yeah, I don't want to die, I don't want to die. And
that's a pretty mixed
signal.
They
killed them anyway.
Well, okay, she didn't say, I don't want to die. She says, I'm not ready yet.
Yes.
Which is kind of saying I don't want to die. All right. Last topic. Italy's constitutional court rules that assisting suicide is not always a crime. A constitutional court in Italy has ruled that assisting suicide may be legal if certain conditions are met. According to The Guardian, anyone who, quote, facilitates suicidal intention of a patient kept alive by life support treatments and suffering from an irreversible pathology should not be punished under certain conditions. Now, here's something, which is that the guy in question did not have a terminal illness. He was a quadriplegic. And so before Italy even has gotten to the point of legalizing assisted suicide, they're already saying that it's not just for people who are at the end of life. It's for people who have disabilities.
Yeah.
So,
And the law is
right,
yet.
right. It hasn't been passed through the legislature.
Yeah.
So
So why this law?
So the court is saying it goes beyond people who are at the end of life. So those who say, "Oh no, this isn't about disabled people," those people are, The ruling came in the prosecution of Marco Cappato, who drove Fabiano Antoniani to Switzerland, where he had assisted suicide in 2017. Antoniani, also known as DJ Fabio, who was paralyzed and blinded in a 2014 car accident, did not have a terminal illness. The court said assisted suicide may be permissible if the person's condition causes physical and psychological suffering that he or she considers intolerable, and with approval by a local ethics committee. Also, public health authorities would have to verify that all conditions are met. And the ruling also calls on Italy's parliament to legislate on the issue. So the court said, you really should deal with this. So that is it for our webcast. If you want more information on the topics that we discuss here, you can visit our Facebook page at facebook.com/toujours vivant, not dead yet, all one word. You can visit our website at tvndy.ca. You can email us at info@tv-ndy.ca, or you can follow us on Twitter @TVNDY. Thanks to Christiana for helping out, and thanks to you for being there. We will see you next time.
See you soon.
Au revoir.
Take care. Bye.